morning, everyone. My name is Lance Fujisaki, and I'm an attorney representing community associations, and have been doing this for a number of years. My materials are in this section, the next section of the booklet, with a blue moniker on the top there. So my assignment is to talk about mediation under what's called Act 196, and that relates to mediation and also arbitration. And also I'm going to talk about some tips that I have for trying to help people in condominium associations live together better, I think, with dealing with their differences. So regarding mediation, could I see a show of hands if you know what mediation is? Okay, so most people know what it's about. Have you ever participated in a mediation? Okay, a few of you. Okay, so mediation is an informal procedure. It's often confused with arbitration. Now, arbitration is something that is substantially different. Mediation is a confidential procedure. It's informal. It involves the retention of a neutral, usually called a mediator, somebody who's a third party, and that person will meet with the parties individually and possibly together, but usually individually, and learn about the positions of the parties and try to find ways to connect the parties on whatever the dispute is. Sometimes in the mediation, there'll be opening statements that are given with everyone present. But I think in my experience, it's that the mediator would meet with the parties individually. So if you have a dispute that's mediated, there's a good chance that you may never see the other side. All of the communications are basically controlled by the mediator. So the power of mediation is that by having a neutral involved who can talk with the parties confidentially, the mediator can kind of develop an understanding of the contours of the different positions and then try to weave together an agreement, knowing things that the other side doesn't know. And so I think it's an extremely effective procedure. I strongly recommend it, but it is not foolproof, and so you just have to go into that with sort of an open mind. What I'd like to do is to ask you to turn to page 8 of my materials. On the bottom it says page 8 of 11. And what I provided on these 2 pages, as well as the next page, are verbatim excerpts of the Hawaii Revised Statutes, Chapter 514B. Is everyone familiar with Chapter 514B? Okay, that is the Condominium Property Act. And so the legislature amended Section 161, 514B 161 to change the mediation laws. And so on this table, if you want to see what the differences are, the first column is the existing law, and the second column is the law that becomes effective on January 2, 2019. So this law is not in effect yet, but it will be very shortly. And you can see from that comparison, some of the law is very similar and some of it is completely new. Most of it is new. And then if you turn to page 10 and 11, you'll see at the top of page 10 voluntary binding arbitration, and I'll talk about this, but this is a new section. It doesn't have a section number yet. And below that is mandatory non-binding arbitration. This law has been around for many years, and there were no changes to that section, but I provide that because it may be confusing when you read the Condominium Property Act. You're going to see two arbitration provisions, and they're two completely different procedures. So the differences between mediation and arbitration. Mediation is what I described, informal. It's basically a settlement conference or a settlement negotiation, and the parties can walk away from that without any agreement, and they just move on to whatever dispute resolution process they have, or perhaps they just go on living with their differences. But arbitration is essentially an informal trial, and I say trial because for one thing, there's an outcome, a decision from the arbitration, and the arbitrator will render a ruling that's either binding if it's under the binding arbitration statute, or it's not binding, but you will get an award. And the other thing is that it's an evidentiary proceeding. So with mediation, it's basically a talk story session. There are no witnesses that are called. The principals are present, and they state their stories, explain their positions. In arbitration, it's like a trial because each side needs to call witnesses and put on evidence so that there's a record for the arbitrator to make a decision. And so it's a much more involved and complicated and expensive process. But it's similar to mediation in that the parties have to agree on somebody who's going to serve as a neutral to make these decisions. So let me just go through the materials that I created here, and I thought the easiest way to cover it would just be to ask some questions that you might have about the statute, and I'll go through these as quickly as I can. First question, what kinds of disputes are subject to mandatory mediation? So mandatory mediation is for disputes between the unit owner and the board, unit owner and the managing agent, board members and the board, or directors and managing agents and the board. And I just noticed something here that it doesn't really talk about disputes between unit owners and unit owners. So it has to involve the association or managing agent, or it can also involve the developer, but it has to fall within these categories. When does the dispute qualify for mandatory mediation? It has to involve your governing documents. I assume everybody's familiar with their declaration, bylaws, house rules, things of that sort. That's what this mediation section is about. The parties have not already mediated, so if you did it once before, you can't do it again under the statute. And if the dispute is in litigation or arbitration, there's special procedures for mediating at that stage. The types of question 2 is what kinds of disputes are excluded. This has been just slightly tweaked from the old law. Basically, if it involves property damage or bodily injury, that's not to be mediated. Disputes involving assessments, so if there's collections, that is covered by a different section. If there are personal injury claims, or if there are insurance issues or consequences on the insurance coverage, those are not going to be covered by the mediation. 3, may other issues be included in the mediation? And yes, but it needs to be by mutual consent of the parties. Otherwise, it'll be limited to the mandatory issues. 4, can the board or other responding party deny a request for mediation? The short answer is no. If an owner demands mediation, or if the association demands mediation, it's mandatory. And in my experience, the parties are usually amenable to mediation anyway. 5, what is evaluative mediation as opposed to facilitative mediation? And I'll talk about the reason why I asked this question, because it does have consequences. So facilitative mediation is where the mediator acts as a facilitator to try to get the parties to reach a mutual solution. The focus is on reaching an agreement. Evaluative mediation is more like a trial or arbitration, only in the sense that it results in some sort of an determination, although informal and not binding, nevertheless a determination or evaluation of the strengths of one side versus the other. And so the mediator would need to obtain whatever information is necessary, and also have the expertise to analyze these issues. Depending upon what the issue is, because condominium projects are so complicated, and there could be interplay of many different provisions, not only provisions within your declaration or bylaws, and if you ever read your declaration or bylaws, you realize that it's a pretty complicated legal document, and sometimes not all of the provisions fit well together, but you have to add on to that Chapter 514B, which has I don't know, well, depending upon the version, it can span well over 100 pages. The mediator would have to be able to process all of that information. There's also, until the end of the year, Chapter 514A, which is the original, or not the original, the previous version of the Condominium Property Act, which is still in effect. And depending upon what the issue is, also the Nonprofit Corporation Act, Chapter 414D, Robert's Rules of Order for procedural issues. It can be a very complicated thing. So obviously a competent mediator with expertise in those areas would be necessary. But the next question is, may we choose facilitative mediation if the other side requests evaluative mediation? So the reason why I distinguish evaluative from facilitative is that the statute talks about these two kinds of mediations. And if one side requests evaluative, then it will have to be evaluative mediation. In my experience, there is a component of evaluative mediation and facilitative mediation, because a mediator would very often tell one side or the other whether the mediator, whether it's a retired judge or attorney, whether their claims are good or not good, even in facilitative mediation. And I think in evaluative mediation, I think the mediator would also try to facilitate the dispute. But technically, it has to be an evaluative mediation if it's requested. And there's also another significant reason. And so if you have a pen, I would mark under question 5, evaluative mediation, just so that you have it there in your materials. And I'll talk about this more later, but when we talk about the new subsidized arbitration process, that process is only effective for evaluative mediations. So I would just write next to that, those words, evaluative mediation, I would write required for subsidized arbitration. So turning to page 4,